a very warm welcome, ladies and gentlemen, respected Rupam Banerjee, sir, and dear participants. Good evening, ladies and gentlemen. I'm Riya Sharma, an executive member of Legal Vidya, and it is my great pleasure to welcome each and every one of you to our highly anticipated webinar on mastering moot court, strategies, tips, and winning techniques unveiled. In the dynamic realm of moot court competitions, the ability to craft compelling arguments and present them with finesse is a skill that sets champions apart. Whether you are a law student gearing up for a competition or a seasoned practitioner looking to refine your appellate advocacy, this webinar is your gateway to unlocking the secrets of success in the moot court arena. Before we begin the webinar, I would like to introduce Legal Vidya to you all. Legal Vidya is a platform that was founded in the year 2021 with the vision of empowering young lawyers. The organization provides a comprehensive portal where people can enhance their knowledge and grow their expertise in the field of law. Legal Vidya offers various opportunities such as internship programs, a platform to publish articles, and host interactive webinars and sessions for its members. Now, it is with great pleasure and honor that I introduce our distinguished speaker for today's webinar is Mr. Rupam Banerjee, sir. He is the founder of the Amicus Curiae, which is currently the eighth largest legal portal in India and is acknowledged as one of the top 500 organizations on all sectors of India by the Grow app. He too runs a team of more than 2,000 plus law students from across 80 plus law schools in India. He has been an avid mooter and enthusiastic debater in his law school days and have additionally triumphed over several of moot court competitions and debate competitions at national levels. I would like to request you all to please keep your mic on, mute, and keep your video off during the session. And if you have any queries or any questions, please ask them at last when the speaker will ask you to do so. We will also provide you the feedback form at the end of the session. Kindly fill that form. So without further ado, let us warmly welcome Rupam Banerjee to the virtual stage. We eagerly await the invaluable wisdom and perspectives they are about to share with us. Over to you, sir. So your voice is breaking.
Just give me a moment.
So now you are audible.
Yeah. Is it clear now?
Yes, sir.
Okay. So thank you so much, Riya, for such a beautiful introduction. I would like to thank Rahul and Sakshi for inviting me for this interesting topic. I really, don't want to give any lecture to the students. I believe there is law student right from first year to fifth year as well. So I don't want to be in a lecture series. I really want to interact with all of the participants that is present here so that, I get to know what exactly you are wanting to learn from this particular webinar. What is your suggestions? What the topics you are looking forward for me to cover in this particular webinar? So, I really want this thing to be very interactive, and I really request all the participants to, you can either, unmute or you can write in the chat box. I'll read it out for you. So, what are the things that you are looking forward to learn from this particular webinar? If you could write something so that I can get an idea that what exactly you people are thinking of this. You can write in the chat box. Yeah. Okay. Okay, so courtroom mannerism, research definitely I'll cover. Roles of mooters and researcher. All right. So, what is the idea, like basic idea, you people have of a moot court? Like, what do you understand by this particular term, that what is a moot court all about? You can write your answers. Right. All right. Definitely. I'll cover all of those. Definitely, a lot of questions was regarding the research part. So definitely, I'll be covering, how to, find all those case laws that is relevant to your arguments from both the sides. Definitely. Anisha, the question was, if you could please explain what, according to you, is a moot court. Right. Right. Okay. Okay. Thank you. Thank you so much. Yeah, I got it. So, basically, if I define moot court in a very simple language, so a moot court is a stimulation of a real court to give the students an insight on dealing with a legal problem and how to present a case in front of a judge, right? So it's a fictitious court that has been created with a fictitious problem so that you, being a law student, when you're there in your law school days, you learn the art of argument, the oral rounds, you learn the art of drafting, preparing briefs, memorials, and the courtroom mannerism that all of you are talking about, right? Because these are very essentials when you pass out of your 3-year law school or 5-year law school. You don't get much of an opportunity or much of a time to go to a court and learn. So nowadays, a lot of law schools are actually, taking this moot court culture to newer heights, and they're organizing several national, international moot courts, and they're also organizing intra moot court for their particular students of their particular branches, just only to make sure that you people, improve in all overall. Because if you're participating in a moot court, there is not a particular single skills that you're developing. There are multiple skills that you develop while you participate in a moot court. You develop the way you speak, the mannerism, you always develop a disciplined body language, you develop argumentative skills, you develop writing skills, drafting skills, briefing skills, researching skills, as well as very important, the communication skills, the speaking skills. So that is, that is why you see a lot of this, a lot of these days, we see a lot of competition like trial appellate competition, then which is national moot court competition, international moot court competitions happening across, right? So the main and the purpose is to make sure of the law school is to train their law students in the law school initial days only to learn about the mannerism in which, after they pass out, once they go to the court, they can actually have the basic idea how the normal court functions, right? Right. So that is something, a basic definition of a moot court. I'll share my screen with you. I have something, covered overall topics that people are asking. I'll try to cover all of those. And in case I do not cover any such or miss something, then, definitely in the Q&A session, you can ask some questions and I'll try to answer according to my capabilities. So just give me a moment. I'll just share my screen. So is my screen visible? Can anyone just confirm me?
Yes, sir. Your,
Oh,
your screen is visible.
okay. Thank you. So as I was telling, yeah, thank you so much. Thank you. As I was telling you, people, a moot court is basically a fictitious court or a stimulation of a real court that is, allowed to give students an insight about dealing with the legal problems. I know you get a case, you get a moot problem. There are facts, there are issues, you go and solve those issues and everything. And as I've included, the main goal of this moot court competition is to teach different important lawyering skills, case preparation, legal analysis, written advocacy, articulations, and everything, right? So this is what you've learned. Now, what are the main aspects of a moot court? Like the moot court has been divided into two different aspects. Majorly, first of all, a memorial preparation to prepare the memorial based on the moot problem that you have. Second comes the oral presentation. Firstly, we'll be exploring about the memorial preparation, and then I'll go into the oral presentation thing. So firstly, so basically, whenever you participate in a moot court competition, you mostly see you get the brochure, you get the moot problem, right? So there is 4 to 5 pages of moot problem, and sometimes it goes into 20, 25 pages as well. It depends from which college you're participating, which problem they're facing into. So firstly, all the team that we prepare, the speaker, one speaker to the researcher, all three of you are required to, initially study the moot proposition to know what are the facts of the case that is talking about. Then you need to see the issues and which particular law it is actually focusing. There are several moot court competition happening that's focused on a particular law. You see IPR law, you see arbitration moot court competition, you see space laws moot court competition coming up, constitutional law moot court competition coming up, and some moot court competition are a mix of both. Okay, so you see a lot of time there is a mix of constitution, there is a mix of criminal law as well, and sometimes it's a mix of subjects as well. So after initially studying of the moot proposition, you have to actually see what exactly the moot proposition is talking about, right? Then you start your research part. Okay, so now it's a thorough research, but that you need to do. Also, get one thing in mind, that research part is not only for the researcher. No, the amount of research work the researcher need to do is the same amount of research the speaker one, the speaker two needs to do as well. Because the researcher might be doing the research if he or she prepares the memorial. After all, at the time of the oral argument, it's the speaker who need to speak in front of the judge, face the question of the judge, do all this drilling down. It's always better from the start itself, all three of you sit together, maybe on a virtual platform like this, or if they're in the college, then on a physical forum, and you search everything, right? So coming about the moot problem, right? So first of all, try to by heart the moot problem that is there. By the time you are actually appearing for the competition, I'll definitely suggest try to take a moot court if you really are looking forward to win this moot court, or at least have some good outcome. Yes. Fine. Okay. So basically, can people were actually
Mohammed,
unmuting?
do not unmute yourself. Do not unmute yourself again and again.
Oh, thank you. So basically, I was suggesting that if you really want a good outcome about the competition that you're appearing, then at least try to choose a moot court that is at least 1.5 months, 2 months from the date you are registering that particular moot court competition. I'm telling you this because that gives you ample time to prepare for yourself. Because to prepare to get the best memorial award or to get the best speaker or everything that you see all these teams start preparing a very way long back from the the day the competition starts. So basically you need to have ample amount of time so that we actually study the moot problem, make the memorial, do all of these pleadings and do all of this dress rehearsal in front of your faculties or the conveners that is there in your moot societies, and then come prepared, fully prepared to a moot court competition. Then only you can see qualifying the prelim round, quarters round, semis round, and we're actually getting something out of it. Otherwise, just for the sake of moot court competitions or just for the going and visiting the colleges, you can do that, but you can't really win it. So always try to take a moot court competition in which you have at least ample amount of time, at least a month time, so that you have enough time in your hands to actually prepare for it. So as I was mentioning, that you have to by heart the moot problem, right? While you are there in the competitions, you are actually arguing and you are actually answering the questions of the judges. If the judge asks you that is there any mention about the particular fact that you are speaking in the particular moot problem, then it should be there in your mind ki para number this was been taught and this, so this is the relevant fact that I'm talking about. Okay, because the judges always try to see how exactly the counsels you are representing, how well prepared you are while you are arguing the questions. Because if you by any chance doesn't know the facts, or if you just go like, see, it shows a negative impact. I really don't know, because some judges, it's up to the judge's discretion if they want to deduct some marks or not, but it's really look very odd if you really don't know or by heart the facts of the case and you just search in the moot problem in front of the judge where is the fact. So just try to read so much about the moot problem that you exactly know in which paragraph which fact has been told. Okay, at least you have all these things right. Then you have to then separate the material and the immaterial facts. Okay, as you've seen, every moot court problem. For an example, if I'm giving, they sell that it is the largest democracy, and they give some name like India's name to be Indica. Okay, it has the highest population and everything. So these are the facts, but these are not material facts, right? These are some immaterial facts that you need to do. That might, it might turn into material facts if you see the issues accordingly. But for an example, if the issues are something else, then you can consider this kind of facts the immaterial facts. Then what are the material facts? Material facts, after the given explanation of a particular country, when you come to see the actual problem, right? So while you're reading the moot court, take a marker, or so not markers or a highlighter, and just highlight the relevant para, highlight the material facts that is actually will help you to solve the particular issues that has been given. Also, it is very much important for you people to understand the keywords. What are the keywords? For an example, if it has been said a riot, okay, so riot is a keyword because that riot can be anything. Okay, it's a religious riot or something else. You need to find this kind of keyword that will actually help you to prepare your argument, the oral arguments, the argument advance, right? You do that. And fourth, and one of the major part of this particular, while you're preparing a memorial, is identification of the jurisdiction. I see a lot of students, previously were participating in different moot court competition while I was a student and I used to participate. Or right now, I see a lot of students make very silly mistakes in the part of jurisdiction. And if you won't believe that if your jurisdiction is wrong, no matter how good the memorial is, how best the memorial is, your case would be straight away rejected from the honorable bench. So you need to make sure that you clear the jurisdiction part. For an example, if you think a particular writ would be applied in a particular jurisdiction, then a lot of time the judges would be asking you which particular writ. So you need to know these 5 writs and what they tell about it. Okay, if it's a SLP, then you have to write the SLP section. If it is come under Article 32 or 1, then you have to write Article 32 accordingly, right? So, or if it's a PIL, then accordingly. So you have to be very clear about the jurisdiction part while you are participating in a moot court competition, because in case jurisdiction is wrong, as I already mentioned, no matter how good the memorial is, how well the content is written there, how good the formatting is, the case would be dismissed on a fast pass itself because the jurisdiction is incorrect and the court will directly ask you to remove this particular case because they cannot adjudicate a matter that is beyond their jurisdiction. So you need to find out that. Okay, so basically breaking up the issues. So I believe I really don't know how many like the participants are from which colleges, but I believe IRAC method has been taught in some of the NLUs that I've visited. But not a problem. You can see what IRAC method is. Okay, so the issues that you are there. First, you need to go through this particular method. What is the issue, the rule, the laws and precedents that is attached to this particular issues, the argument that you prepare, and then the conclusion. Okay, so what are the 3 or 4 issues that has been given in your moot problem? You need to break all the 4 issues in this IRAC method, right? You can do it in any other method. I suggest IRAC method because I feel this is comfortable one. So, in case if there is any particular method that you people believe would actually help you or is less time consuming or it is more suitable to you, you can do that, right? But I prefer this kind of method so that it becomes easy for me. And I guess many of the students who have used the IRAC methods who actually, get into depth of the particular issues, right? So, a lot of time, if you see the moot problem is actually based upon a particular real life case. A lot of moot could happen this time. So if you're there, actually, if you really search those kind of cases, it becomes very easy for you to actually get the original arguments that has been done in the court from both the sides, from the petitioner and the respondent as well. So you need to break the issues into you to see which laws are coming to it, which sections are coming into it, which articles are coming into it, what are the arguments that has been done by in the original case, and what is the conclusion the judge have given. Okay, so if you find those kind of cases, on if you are lucky enough, if your moot problem is based on some original cases, then I believe you should utilize what has been there in the original case, be it a judgment of the Supreme Court or the Honorable High Court or any particular court that you're talking about. Then go through it, read those particular original judgment so that it would become very easy for you to actually know If you read the original judgment, what happened is that you already predetermine what kind of questions can be asked to you by your opponent, learned opponent, or by the honorable bench. So you get yourself more prepared in that particular form. Okay. So now coming about the contents of the memorial. So basically, a memorial is make of 30 to 35 pages. Mostly 30 pages I've seen. Some colleges gives an extension to 35 pages as well. So you need to prepare a memorial from both the sides. So these are the contents that you need to have in your memorial for both the sides that you're favoring. So the first one is the cover page. I'll definitely cover what need to be written there as well. But just to see an overview, first one is the cover page, then comes the table of content, then the list of abbreviations that you use throughout the memorial, then the index of authorities definitely, and as I mentioned, statement of jurisdiction, the facts that has already been mentioned in your moot problem. Then comes the issues that is there, summary of arguments, argument advance, prayers as well, right? So I'll come in brief. Okay, so that basically the cover page, right? The cover page comes of the forum that you are appearing before the which particular court. Okay. So this has an indirect link with the jurisdiction as well, right? Because if you really don't know, if the moot problem doesn't specifically tells you about which court you are appearing, then you need to really need to work on the jurisdiction, because according to the jurisdiction you would be able to find out the court in case it's not been mentioned. Mostly in the moot problem, the court has been mentioned that the courses, this particular case has been pending in front of the Honorable Supreme Court, 5 judgment, 3 judgment, whatever it is, and accordingly it has been written. In case it is not mentioned, you can try the other way out. Then the name of the case. So again, very vital part. This is very silly mistakes. It's something that you people don't do doingly, but this kind of silly mistakes you can find in the memorial that, if you're a petitioner and you do not know the right name of the petitioner, suppose there are 4 to 5, people in the particular case, and you really don't know that which particular, people are exactly to come under the petitioner or under the respondent. So choose wisely, and that is the main reason I've told you at the starting that read the moot problem very thoroughly again and again, so that you just by heart the moot problem, right? So that you know what is the petitioner, like if there is more than one petitioner, then you have to write accordingly, petitioner 1, 2, 3, you have to write on the right hand side, right? Versus if it's a criminal offense, then again 68 or something, right? Then the title of the memorial, that are you appealing for the appellant side or the respondent side, petitioner, everything has to be written. Then jurisdiction you need to write, and thirdly the team code that would be allotted by your respected college or the platform in which you're participating. So that is the main contents that you need to do in the cover page. Now come on the table of contents. So basically the index of files, that structure format is there, argument advance, subheadings, everything. But whatever you will be covering in your memorial comes under the table of content part. Okay, so the list of abbreviations. So list of abbreviations are the short forms that you people actually will be using in the memorial. For example, if you might use, you would not be using learned word every time. So you might be using LD. Okay, so under the list of abbreviation, you'd be writing LD, and what is the full form of the LD that we're using? We also write honorable as not the full form HONBLE and a colon BLE. Should be writing honorable and writing then the honorable. Like what does this particular short form means? So all the abbreviations that you use in the entire memorial, you need to actually write those in the list of abbreviation part of the memorial. Okay, so index of authority I talked about. So basically index of authority talks about, as in the moot problem, you would be dealing with a lot of case laws. You'd be, redirecting a lot of case laws that suppose your argument, right? So in the index of authority, you need to mention all those things like cases, like which particular portals that have gone through, which particular books you have gone through, articles, parliamentary words, everything that you have taken. You need to write those particular things. You need to give due credit to that, right? Then comes the statement of jurisdiction. All right. So basically, as I was explaining, jurisdiction are part. For an example, if it's SLP, a special petition, right? So, a lot of people would be knowing that SLP would be filed, in case if you're going from High Court to Supreme Court. For that, again, you have to read the moot problem. Like the case that you are actually challenging in the front of Supreme Court, are you coming directly to the Supreme Court? Then there will be separate jurisdiction applied. Or was the court first gone to the High Court and then it's an appeal that is coming to the Supreme Court? So for that, again, you have to read the moot problem accordingly. And then you have to justify the jurisdiction. right? And you need to know different jurisdictions as well. So there are different jurisdictions. Some of the jurisdiction that is commonly used in this moot problem are, I've just given an example. There's a lot of jurisdictional issues, but just for an example, Article 136, 32, 26, you need to explain what that Article 136 of the Constitution tells about and how that particular jurisdiction is actually applying in your case. So under the statement of jurisdiction heading, you need to mention this kind of thing. You need to explain the article and then relate how this particular jurisdiction is actually helping you in the case, right? Then comes the statement of facts. So as I already mentioned, the summary of relevant facts that you mentioned, right? So for an example, if your moot problem is of 20 pages, the statement of facts cannot be of 20 pages, right? Because the overall limit that you have is 30 pages, and the most important part is the argument advance part of your memorial. So you have to summarize the statement in two parts, right? So first you do headings, subheadings, maybe in 2 to 3 pages, you summarize the statement of facts. Okay. Also, do not pre-assume any facts. Okay. Do not ever do the pre-assumption on the facts. This might happen or this might happen, because you cannot really argue anything apart from what has been already given to you, right? Also, whatever things that you are writing in your memorials is the only things that you need to speak. So there should not be any presumptions or assumptions coming into the while summarizing the particular facts. So you need to be very clear about how to summarize the particular facts, because you have a page limit, you have a page restriction. So it doesn't matter the moot problem is of 4 pages, 2 pages, or of 20 pages. You need to by max you need to close the summary statement of facts within 2 pages. That's the max. What you can do is that you can make some headings and subheadings. So it will make a heading a broader heading. For an example, if there is a conflict about the jurisdiction or the constitutionality of a particular statement, then you can rather than writing the entire thing, just brief the entire thing in a broader heading. Okay. For an example, if the judges ask you, then under the broader sense you can actually explain that to them. So that is one of the tricks that you can use. Rather than writing everything on the facts, you can keep on heading and subheading parts and keep a broader heading for an example, right? And then comes the statement of issues. So again, the issues mostly are given in the moot problem. Okay, so basically you have to introduce the particular issues. Okay, so introducing a particular issues, you can write in a single sentence or 2 to 3 sentences. You don't have to write the entire thing, because you'll be covering all those issues on later part in your moot memorial as well. So you need to start with whether this and everything. So it depends from the moot problem, like how you want to start the particular issues, right? It has generally been given on the moot problem itself. So you can write the statement of issues accordingly. Now comes the summary of the arguments part. So basically, before going for the argument advanced stage, mostly, a lot of judges won't be having the entire time to reach those 10 to 12 pages of your argument advance. So, what exactly, while you are explaining, being the counsel, the judge would actually go into the summary of arguments. So just make sure whatever argument advance that you're preparing. For an example, if your issue 1 in summary of argument advance is a 4 to 5 pages, you need to brief what exactly the main point out of it in the summary of arguments in, I believe, not more than 1 or 2 para. All right. So all the facts that you have, so all the issues that you have, to just give the brief of every arguments on every facts in not more than 2 paragraphs or something, so that whenever the judge reads it out, he or she will be able to understand what exactly you are dealing with, what exactly is your side of story, and what exactly you want to say to the judge. Okay, because a lot of time a judge would be judging prelim quarters, so he or she might not be in a mental state to again go for the arguments, right? So he would be seeing the summary of argument parts, and accordingly, those kind of things would be so write those relevant part of the particular argument advanced part in the summary of arguments. Now moving ahead would be the argument advanced part. Just give me a moment, guys. So argument advance. So again, as I've told, this is the most important part that you people need to focus on, right? So argument advance would be reflect all the research that you have done. So you need to be very clear and precise of the intention of the counsels, right? And everything should be in a structured format. There should be nexus, as I was already talking about, the facts that has been given in the moot problem and the legal provision included. Okay, because if the facts is X and you are giving A as a legal provision, then it won't work, right? So in the argument advanced part, you need to do the most kind of research. So there are several research formats that you have. There is SCC, Manupatra, Live Law, Bar and Bench. Okay, there is everything. Okay, that has been given. Also, one more important part, to make the argument advance better, always carry a compendium. I see, a very few teams in the moot court competitions carry a compendium, right? In the compendium, what happens? You have the, brief facts of every cases that you've referred. For an example, judges also might not know every cases that you're suggesting. So it is always better to carry a compendium, and there should be a brief of the particular case that you're suggesting. So whenever the judge asks that what is the thing that, if you have referred a particular case, what is the relevant relevancy of the particular case in your particular argument, then you can always, forward that compendium to the honorable bench and can tell my lordship or ladyship that this is the paragraph in the compendium. You can read that this is what the case told about and this is how it is reflected. So that is one of the most important part, that do carry a compendium, okay, so that you have everything written, everything, because memorial have a very short of 30 pages, and everything cannot be explained in the memorial. And compendium is allowed in the moot court competition, so it gives you an extra edge over the other teams if you're carrying a compendium and you are explaining everything in details in the compendium, so that the judge go through the compendium and can understand that what exactly you are talking about, right? So the research, whatever research you are doing, whatever case laws you are finding, everything, so that will get covered. Okay. So, but do not write any case laws that is not written in your memorial. You don't write that case laws in the compendium. Whatever things that you've written in your memorial, that thing is only written in the compendium, but on a more wider aspect to give a proper idea to the bench in case it is needed. And compendium, it's very healthy for us, because it become very helpful as well, because it clear a lot of doubts while the judges are asking questions. Like it has done a lot of help for me while I was mooting. So I'll request all the teams who are participating in this competitions to at least have those kind of compendiums where you can write and explain things in brief. That will actually help you to do that. Okay, so this comes under the formatting part. So a lot of moot court competition, if you see, go through the brochure, they mention about which all formatting they prefer. So, it comes under, for an example, this is just an example that all caps are bold, extremely important, bold is important, italics is organized to get an idea. So it depends, formatting would be depends from college to college and everything. Okay, so you'll get to know which formatting formatting style the particular college is asking you to follow, or the institution that you are participating. They'll let you know in the moot brochure which particular formatting they're actually following, right? So accordingly, you can make the headings of the arguments and the other part as well. Now, one of the important aspects is this prayer as well. Okay, so prayer is very important, right? Because, for an example, if you are a plaintiff, right, or appellant, and your prayers is in favor of the opposition side, then definitely you won't be getting the reliefs that you are claiming, right? The prayers plays a very important role. So you have to make sure whatever relief that you are claiming is actually bringing a nexus to the arguments that you have done throughout this 20 or 30 minutes, right? You're very clear to the point and use the correct terms as well. As I was talking about, you people can take some screenshot out of this. These are the legal research portals through which you can find the. Okay. I believe a lot of the colleges have the subscriptions. There are different other sites as well. A lot of you people would be suggesting that you don't have to use Indian Canon. I also specifically don't suggest of using Indian Canon for referring purposes. But if you want to read a case laws, and if you do not have the subscription of all these particular things, I believe you can at least go and read through Indian Canons and there are some other websites. I'm not able to recollect right now, which are free, and you're able to get all those cases on those. But yeah, don't give credit to Indian Canon in the citations part. Okay, if you're citing something, don't cite Indian Canon, cite SCC, Manupatra, and other more suitable portals. But yeah, in case if you do not have the subscription, then definitely you can go at least read the case from Indian Canon. that will actually help you, right? Yeah. Okay. So materials to be searched upon, right? So basically, these are some materials that you need to search upon: the case laws, the research paper, legal notes, commentary, BR Acts, everything. These are through which you can actually, search the cases, right? You might read books. You have the library. There are a lot of articles, there are a lot of journals that have some things. So you can take cases from there, and you can cite those cases. And again, make sure the journal that you're citing, the books that you're referring, are actually authentic, right? Or the notes that you're suggesting, right? Or the research paper that you are actually taking references from. Those all should be very authentic and from the authentic sources. Okay, and again, case law mein, you people don't have to write the entire case. Okay, you have to very, as I mentioned, a very crisp thing. Okay, just the facts, issues, the ratios, and the judgment. Okay, you don't have to deep delve into the case. Okay, because again, there is a pace constraint, and even you cannot make the compendium of thousands of pages of compendium. That has to be, though it doesn't have any limit, but for you to keep it handy, it should be within 50, 60, 70 pages, not more than that, so that you exactly find whichever case you are taking into. So short may, there is a lot of websites you might find who gives case briefs, right? Who gives you case summaries. So take from those. You can take a note from those websites, and then figure out the case law that you are putting into. So it will brief everything. So these are some general tips for actually the memorial that you need to do. Clear writing, open to changes, and again, for an example, I'll always suggest do not submit the memorial on the deadline. Try to submit 1 or 2 days prior, so that you can actually get your memorial checked by your seniors, the conveners, all the faculties. So they will actually help you to know if there is any changes needed. If you want to, if there is a condition for plagiarism in the memorial, then go run it through Turnitin. Or if you want to check there is a spelling mistake or a grammatical error, then go through the run the memorial through Grammarly app. Okay, proofread the memorial, 3 eyes, 4 eyes, 3 times, 4 times, everything. Okay, simple English. Do not write everything legal language and everything. You might use some legal languages. It might sound very cool to you, but you don't have to write extraordinary English to impress the judges, right? Also, do not try to, it is a suggestion, because a lot of time this legal maxim that you use, you cannot remember, right? Because stage that you are set, you are actually nervous. So at that particular point of time, there might be a very nervousness, and you might not able to remember every maxims that you have written. So do not try to write many kind of legal maxims that you're using. These are very simple short tips that you need to keep in mind while you're drafting your memorial, so that while you argue, your orators can be of great help. Actually, they don't have to face any problem from the honorable bench. So make sure that you do that, and I always try to finish the memorial drafting 2 days or 3 days prior to the submission, so that you people have enough time to proofread those. Try not to submit at the last stage, because then you don't be having any time on proofreading it. And if there is any silly mistake or grammatical errors, those will cut marks. And to get the best memorial, these general tips should be taken into kind consideration. Otherwise, it would be a great problem, because these are very silly mistakes that students make while they're drafting the memorials. So keep these points in mind, and try to apply it from your next note, so that you can get some favorable results that you're talking about. And at the end of the day, it's the formatting, right? So it's formatting the way suggested. For an example, if it's a 20th Blue Book citations, so there is a specific font size, font uh, uh, style, then the spacing, the line spacing. For an example, if the line spacing is 1.5, it should be uniform throughout the memorial. It shouldn't be key. Sometimes it's 1.5, sometimes it's 2.5. That looks very odd. It should have borders at the side of the memorial. So this is all about that you need to do while you're preparing for the memorial, right? I'll stop sharing my screen. I'll take some questions from this, and then I'll move forward with the oral argument. So Ria, can you take some questions? If there is any particular questions uh, till now, what I have taught regarding the memorial. See, Surya, you have asked one important question, right? So plaintiff, petitioner, appellant, everything. So you can, the question that you have asked, the differences is actually what you can read through. The answer is actually in the question itself. Who is an appellant, right? The person who appeals. And when can you appeal, right? If you're moving from one court to another, right? So it's appellant. Plaintiff, I don't know if written CPC or not. Plaintiff comes for the civil cases. So if you read CRPC, CPC, everything, these things can be very clear. See, these are very, we use these kind of terms, but they're very easy to understand, basically, right? If you have written IPC, CRPC, and CPC, you'll be able to understand exactly. Yes, Ashish, I'll try to share this PPT with the organizers, and definitely they might share it with you. Could we write page numbers? No, you shouldn't write page number beside case laws. Page number should be written after at the below of every pages, right? So that is something. Page number should be given because index of authority is there. So in index you have to actually mention which particular heading comes on which page, so that it becomes easy for the judges who are actually checking your memorials. So not beside the case number, but something. Manvi, no, I'll not suggest everyone to directly go into the rationals before the intra. I'll always try, a lot of these colleges, I really don't know which college you are from, but a lot of these colleges, before sending a particular team on a national competition, they organize an intra. And the best team from the college is been sent for this national competition. There might be some other provision from different law schools, but that is the best part. You take part in the intra, prove that you are worth it of the competition, and then go. Just for the sake of these moot court competitions, don't go, because this kind of moot court competition are really very costly. Because if it's a physical moot court competition, you need to firstly give the registration amount, 3,000, 5,000, 6,000, whatever it is. Then take out this printout of 60 pages of memorial, and that to 5,566 copies these people ask for, right? And then you have to arrange for tickets with the flight ticket or the train ticket. Okay, so why to bear such cost? If you're not sure about your participation in the competition. Okay, so prove your worth in your college so that you are the best team available in your college, and then only invest the amount so that you can at least get the ROI. No, you can definitely go for the national for an experience that you're suggesting, but if you really want to win, then keep all these factors in mind, right? Yeah. Yes, then my index of authority, yes. Index of authority, you can cite, you can write. Yes, footnoting again. Footnoting or the formatting style is generally been specified in the Moot brochure. तो अगर आप उसको पढ़ोगे अच्छे से तो वहाँ पे स्पेसिफाई हो जाएगा. Yeah. See, if they are mentioning about a particular footnoting style, for an example, if they mention ki formatting style would be 20th Blue Book, then you can Google it, what is 20th Blue Book, right? You will be getting a PDF or the 21st Blue Book, whatever it is. Or if they're accepting OSCOLA, ILI, whatever they're accepting, you will get a book. So there, everything in details has been written, ki font style kya hoga, font size kya hoga, every minute detail has been given. See, less number of prayer or less number of issues से ऐसा कुछ नहीं हो सकता. See, your prayer should be very definite. For an example, if you are the respondent side, you would be actually defending yourself from all the allegations made by the petitioner, right? So you have to pray according to the issues framed and according to the arguments that the other party might do it. Okay. Ayush, as I mentioned, relevant case laws के लिए you need to, आपके पास 2-3 options है. You can go through the different books. अगर online करना चाहते हो आप different journals पे जाओ. And again, just for the sake, I have seen a lot of students actually, you will be seeing that a lot of the students actually, just to make sure the memorial looks very good, they mention many case laws, right? And at the end of the day, we find out that a lot of these case laws aren't relevant to the actual case. So just make sure that whatever case laws that you are suggesting or writing in your memorial are actually relevant. So if you mention only 4 case laws and all those 4 case laws are relevant to your memorial, no, I can challenge you, you can win this moot court competition without any doubt. You don't have to mention 10, 15, 20 case laws in your moot memorial. So if it is 4 to 5 case laws that you are mentioning, and all those 4 or 5 case laws are relevant to the arguments that you are making from whichever sides, you would be winning that particular competition. No doubt in that. Okay. Do not try to mention just for the sake ki show off करने के लिए मैंने 10 case laws डाल दिया, ऊपर लिख देते हैं case laws. Do not do that. Bharti, I believe I've already explained this, how to write this particular good memorial. All the points that I've told right now are, if people have to keep in mind while you're drafting the memorial. Okay, I'll be try to share this PPT with the organizers, and you can do that. Okay. Sakshi, see, as a speaker and everything, as a researcher, everything, you people need to, as I already mentioned in the first, that try to choose a moot court competition. The time that you are registering for the competition and the time for which the competition is to be held should be at least 1 to 1.5 months at least. Okay, and minimum is to 1 month, so that you give enough time to prepare a draft a memorial. Because again, I'll be coming to the oral arguments, but again, do not try to practice the oral argument before you finish the moot memorial, right? So try to finish the moot memorial as early as possible and try to submit it. And then after submitting the moot memorial, after getting it checked or getting it proofread by yourself as well as by your faculties or whatever conveners that you have or the seniors that you have, then submit this moot memorial. And then in front of them, you request their respective faculties or your moot court societies to take your dress rehearsal and rehearsals. So your faculties would be sitting as a judge, and you practice in front of them and request them to ask whatever questions that is relevant in front of them, so that you practice in front of them and you get an idea what kind of questions that can be asked and according to the particular problem that is there. So that will help you to know, because it is quite obvious that as a student you won't be able to know every and all the answers that the judges would be asking. So I'll be covering that aspect in my next speech, but yeah, that is something. So you can request the faculties on something, that how to exactly go for this oral pieces. I'll be talking about how to present as a respondent, how to present as everything. Well, I'll try to do that, Mamta. If I have something right now, I'll try to do that. Yeah. So moving ahead, the oral arguments, as I mentioned, it's basically the courtroom decorum. Okay. So before proceeding, first try to maintain the courtroom decorum and try to be very disciplined while you're there in a moot court competition. Because if you're entering a courtroom and you'll be sitting, the left hand side is for the petitioner, the right hand side for the respondent, and left hand side to the judge, right? The judge is sitting here. The judge's left hand side would be the petitioner, right hand side would be the respondent. So sit accordingly, whichever side that you have chosen. Then accordingly, whenever the judge comes in, stand up, go in front of him. Do not sit until the judges sit down. So once the judges sit down, then only you sit. So these are very silly mistakes that students make. Also, whenever you are getting your prayer done, try all of you three to stand up. If you're there in the physical mode, virtual mode तो possible नहीं होता कि आप खड़े होकर prayer बोलो. But if you're there in a physical mode, then at least try to stand up while you're praying, because there would be the speaker too who would be speaking the prayer, the speaker one and the researcher stand-ups, right? So these are basic courtroom mannerism you do. So while you're going for the oral argument, for an example, the petition side, you request if the counsel can approach dais or not, right? So once they give just the honorable judge gives the permission, then you go to the dais while you're sitting. Then for an example, if it's a single judge bench and it's a male judge, okay, so you say as your lordship. It's a lady judge, you say as your ladyship. If it's a mixed bench, then you ask that if the counsel can call the bench as my lordship. Okay. Okay. If you ask the bench that if the counsel can call the bench as my lordship. If they say might go ahead, then you can go ahead with the my lordship part. And in case they say call us sir, ma'am, or my ladyship, whatever it is, then accordingly. Okay, but ask accordingly, because you need to be very clear in whatever you are actually calling the honorable bench into, right? Then you request, you can ask the particular bench if they are well versed with the facts or not. In case they say no, then you have to go for the statement of facts. But again, बस petitioner side से statement of facts बोलना है, ठीक है? क्यों petitioner side पहले बोलेगा? Respondent side doesn't really speak about the facts because the petitioner side have already covered it. So, but again, if the judges want the respondent side to again speak of the facts, तो आपको बोलना पड़ेगा. That is again. So after the facts, you'll be asking if the counsel can proceed with the facts of issues of the case. And but before that, you'd be also introducing yourself that counsel 1 would be dealing with issue 1 and 3, or whatever 1 and 2, whatever you have decided among yourself. And my learned co-counsel would be dealing with the remaining 2 issues, that is 3 and 4, or 2 or 4, whatever issues that you have chosen account to. And then proceeding with the issues, you have to explain one by one the facts of the case. And as I already mentioned, कि आपको आप divide कर लो, you write in the subtopics and topics, कैसे बोलोगे, right? So also one of the important thing that a lot of you might have the question कि what if a judge particular asks me a question and I don't know the answer, how to cross question that, right? So don't be blunt and say कि I don't know, something like that. You would say that I'll be get back to you after some time. And in the meantime, your researcher and the other speaker can research upon the questions and then pass you the cheat through the court masters. And while you're finishing your argument, then you can say, my lord, the question that you've asked me at the starting of my argument, the answer is this and that, right? Because it might happen that you do not know every and each questions that would be asked to you. So your researcher, that is the only cause of researcher, that the researcher have all those materials with him, the books, the journal, everything is there with him, right? So he or she would be helping you out with all those questions that has been given. Or if you think that particular question that the honorable bench is asking is of next issue that you are not dealing, then you can politely request the honorable bench, my lord, the question that you're asking would be dealt by my learned co-counsel, right? So they just would agree to it. Okay, so that is how you need to prepare yourself. You might not know each and every questions. And the other way out, sometimes in case you're not able to find out, or your researcher or even the other speaker is not able to find out what exactly the question is or what exactly the answer is, then definitely you can go for plead for some ignorance or something like that, right? So that can be done, but better to try to evade the questions, and in the meantime the researcher and the other speaker can find out the questions, and then accordingly he or she should be passing it out through cheats via court martial, and you can, at the end of your argument, you can actually speak up about the answer that was asked in the first, right? Second speaker would be coming in the same way and would be following the same procedure as I mentioned. The counsel seeks permission to approach the dais, then the counsel seeks process to proceed the issue number 3, whatever it is, the chosen, right? So they'd be doing that. So that is how that has been done. And then come the prayer part. So whenever the second speaker for the petitioner side says this prayer, as I already mentioned, you people have to stand up. All the people have to stand up. And after standing up, the researcher and the speaker who would be speaking about the prayer, right? You people have to just stand up and just show in a bowing position and everything. The speaker would be reading it. And after reading this prayer, bow it down and tell the honorable bench that it was nice arguing before the honorable bench or the honorable court, whatever it is. Just show them this kind of respect. These are very basic and very minute etiquettes that you people like to follow, but that is something you need to do that so that you be there in the very good books of the honorable judges. Then after you finish as a petitioner, the respondent side will be coming in the same way. They'll be doing their argument, they'll be doing their prayer. So this is how it goes. After that, the court master generally tells now the rebuttal round start in case there is the option of rebuttal. So rebuttal is basically where you need to, for example, I am this petitioner, whatever I have spoken, the respondent side have noted down which particular points to counter, and while the respondent side was speaking, maybe in the petitioner I have noted down whichever points I will be countering on their behalf. So again, one speaker, I believe whatever time period it is, for an example, कि अगर 30 मिनट का है, तो 30 मिनट में मान लो कि आपने 2 मिनट का टाइम बचाया है for the rebuttal. So any one speaker, you people have to decide it on your behalf, which speaker 1 or speaker 2, who would be the one who would be going for rebuttal. For example, if I'm the speaker and I've decided I'll go, so I'll go and I'll rebut whichever point rebut का मतलब है countered, right? So you have to counter the point. Okay. Again, while one thing you have to keep in mind, while countering, you don't have to use in unparliamentary words that you are using, right? So you have to very make sure that you follow the courtroom mannerism. कोई भी unparliamentary word आप use नहीं करोगे, है ना? You have to give due respect to the opponent because they are also learned advocates in the present scenario. So you cannot disrespect your learned opponents in that particular fact. With giving due respect, you have to politely counter every point that you have written down while the other party was arguing. The same thing would be done by the defendant aspect as well. And accordingly, based upon your arguments and the rebuttal, the marks are basically given by the honorable judge. That is something that you people need to follow how you need to proceed with the oral arguments, right? So as I've already mentioned, you have to, in oral arguments, what you need to do is basically be very patient and listen to whatever party says. You just can't read the moot court about your own preparations. You need to keep your ears and eyes open to see what your opponent is telling you, right? What are the allegations your opponent is making against you, so that you have enough time to frame the argument in favor of you. That would help you to counter that argument. Because if, for an example, if petitioner is claiming some aspect as a respondent, you need to tell the judge, in case it's a fact, the petitioner have not disclosed a particular fact that has been given in the moot problem that is against their argument and that is in favor of me. So for that, you have to listen whenever your opposition is speaking. It's not that you have prepared yourself very well and you are going and sitting in there and then you are giving your speech. It's not a speech competition. You have to always listen to your opponents, what the opponent is saying, because there is a lot of mistakes that your opponent does while they speak, because all the teams are very tense while they're participating, right? Or they have some nervousness in their mind. So they make some very silly mistakes. You have to catch all those silly mistakes. They might miss those kind of facts. And in case those kind of facts have been missed, then you being the opposition have to, while you are given a chance for rebuttal, you have to rebut in that. Do not rebut while you're arguing. Do not do that. That is not accepted. In the rebuttal, if there is a rebuttal round been organized, then in the rebuttal round, you people can actually rebut all those points. So keep your eyes and ears always open while the other parties, are speaking, so that you make a note कि ये चीज उन्होंने बोला, and accordingly, while there is a rebuttal round, you can do that, right? So these are very few tips and tricks that will actually help you to, get more marks than your opponent, right? So that is something. And again, I'm telling, moot court is not an individual game; it's a team game. It doesn't matter कि आप बहुत अच्छे हो तो आपने जीत लिया. All three of you or all two of you have to perform really, really good and up to your best. Then only you can move with the moot court competition. So again, be sure of choosing a team. Some colleges, by themselves, they allot you the teams. But in some other colleges, you have the option of choosing your team. So in case if you're given an option of choosing your team, so, try to choose the members that would be, do not, for going into competition, आप ये मत देखो कि कौन मेरा दोस्त है. Do not go by that. Try to take persons who will be actually helping you out in the particular rounds. Okay? Or if the college is choosing you, I believe the college gives the best resources that is available in their university to form a team. So you already have the upper end of getting the best talents in the department while you are participating in the moot court competition. But if in case you are choosing a team by your own self, then try to keep aside the friendship circle aside, and try to take people who are actually willing to give you, willing to support you or help you in the all the preparing of the memorial or while they're speaking everything. So try to do that. Because teams plays a very, very vital role. It doesn't matter if you give your 200% and the other two teammates fail to perform, your team is bound to get out in the prelim round or in the first round itself. So that's a very important aspect. Try to focus on the team aspects as well. Team building is very much important. Okay, and anyone or everyone, like anyone, have to take some leadership position while they're in your team, because there should be someone that gets sorted out. Whatever problem might arise while you're there in your team, it should have a very, very short process of getting it sorted. That is one very minute aspect that I believe a lot of people doesn't cover it. But again, in case the team is not good, then again it's a very the chances of winning or performing well in a competition becomes very thinner. So that thing is something important. That is everything about the oral argument that I've talked about, and previously the memorial aspect. So in maybe the upcoming 5 to 10 minutes, I can talk about your questions. I'll try to solve. I believe that I have dealt with all the questions that you people have expected me to speak upon. But in case there is something I missed, then you can write in the chat box and I'll read it out, and I'll try to give answers to the questions in case I've missed out something. Yeah. So yes, good questions. So basically, you can't do anything. That is how a moot court competition goes. It's not for you. The judges would be grilling. The judges would be grilling in the while you are speaking only. So there is a lot of time you might not be able to finish up. So there is no definite way of absconding this particular grilling round. The only polite way is that you can request the judge, my lordship or my ladyship, let me finish my argument once, and then I'll be open to questions, because there is a time foundation in which I have to finish. So I'll definitely answer all of your questions, but first let me finish my argument. You can request the honorable bench. It's up to the bench if that listen or not, but that is the only way out that you can do that, because grilling is something you people have to face while you're arguing, and that definitely I agree to your point. It takes a lot of majority of the speaker's time. That is something that the only way you can do that, because you cannot show your anger or show your ego or attitude to the judge you are not liking it, because if you the judges will not be liking it and they won't be giving you the marks. So that is something. So give utmost respect to the bench and request that, as there is a time constraint, so my lordship, there is a request, let me finish my arguments, and then definitely whatever questions that will coming up, I'll definitely answer those. Yeah. I hope that answers your question. Yes. So how to go through the opponent's memorial? The very easy way is to because opponent's memorial is all about countering your points, right? So you have to actually again read the memorial very thoroughly. You mostly आपको 1 घंटे 2 घंटे पहले memorial मिल जाता है rounds के पहले. So your researcher can do that job in case the speakers are busy preparing their oral arguments. So the researcher will be finding out basically find out the loopholes, like case laws, the opposition, the case law the opposition have mentioned, find out कि those case laws are relevant or not, because then easily it becomes very helpful for you. Also try to take the jurisdiction aspect. बहुत बार opposition jurisdiction में गलती कर देता है तो आपको केस बन जाता है वहाँ पे. केस लॉस में देख लो आप, केस लॉस अगर रेलेवेंट नहीं है वो पॉइंट आप उठा सकते हो आराम से, ठीक है. ये मान लो कोई फैक्ट्स ऐसा जो छुपा रहे, जो बोल नहीं रहे, सो ये माइन्यूट चीज आपको देखना पड़ेगा. ओवरऑल गलती तो वो लोग भी नहीं करेंगे, because they're also coming in the competition to win, right? So you have to just find out the silly mistake that they have done. So this is how you have to read. You have to proofread the opposition memorial accordingly, right? Also, while you are reading, you can actually predict what kind of questions your speakers might have asked you. So like what kind of question the opposition would be asking your speaker, sorry. So you can predict that and you can, acknowledge according to it. Muhammad, I believe there are court masters and you can pass on the cheats to the court masters if you are a researcher, and accordingly the court master would be passing on the cheats to the speaker. Or in case if you want to give some documents as a proof to the honorable bench, then again through court masters you can do that. There are 1 or 2 court masters. It's been present in every courtroom, right? That is how we dealt with. Basic research, I believe, Ashish, I don't understand what do you mean by basic research, but if you talk about the research of this finding case laws and everything, as I mentioned, there you might do not have the subscription of SCC Manupatra, live law bar and bench, and if you have to use those for finding those case laws, but in case if you don't have those particular thing, then definitely you can take the help of the free legal sites, and Indian Canon is one of the biggest. But again, I'm suggesting do not cite any case laws from Indian Canon. You can take it as a reference for finding the case laws, okay? And then you can cite any case laws from the Supreme Court website or directly from the High Court website. That is relevant. Case laws मिल गया, मैंने direct High Court website से या Supreme Court website से आपने cite कर दिया, that is fine. But Indian Canon cite मत करो. But it is easy for in case you don't have this particular options, you can go and find cases in Indian Canon and accordingly you can put in. Okay? Both, Rupesh, both. I believe it depends कि आप कौन सा case ढूंढ रहे हो. There might be some cases, yeah, there might be some acts that you do not find online. So for that, books is important. So I believe you need to use both of these resources of from books as well as from the online research tools. What do you think? See, there is no key essential to be a best speaker, because if you see 50-60 team participate, सब में दो speaker है, like 120-130 लोग participate कर रहे हैं. So you don't have a very definite essentials for being the best speaker. It again the way you present yourself, the courtroom mannerism, the etiquettes, and definitely, or that's something that I forgot to tell you people. Thank you for making me. Is that while you are arguing as a counsel, right? Do not read what is there in the memorial. Do not do that. Okay. Though seeing and reading of a memorial is not something, it's prohibited in a moot court competition, but do not do that, because that doesn't give an impression, and that does, the judges keeps on losing interest on you, because memorial to unke paas bhi hai, right? So they can read it out. What they're expecting you to explain the case to them. So do not read it. As I mentioned, you people have to do the rehearsal 3 to 4 times at least before participating or going for this moot court competition. So make sure that you have the key points mentioned. Sticky notes आप चिपका सकते हो अपने memorials पे कि कौन से relevant para आपको बोलना है वहाँ पे. So accordingly you have to focus, right? Do not read the memorial in front of the judge. You will be having 2 to 3 issues, and accordingly prepare your 2 to 3 issues and then speak it out, right? So do not ever try to read that. So again, अगर आप read कर रहे हो तो आपको best speaker तो नहीं मिलेगा. It shows that how exactly how well prepared you are with the facts of the case or the arguments that you are preparing. So that is something. I hope it clears. Yeah. Citations in see, I don't know which particular websites are you talking about, but actually citation आपको ऊपर में मिल जाता है केस का. ठीक है. You अगर आप SCC में सर्च कर रहे हो तो SCC में आपको top only it gives you the citation. ठीक है. I believe Indian कानून में भी आपको मिल जाता है citation पहले. So you don't have to read the entire case for finding the citations. Generally website provided at the top. But again, it depends from website to website. तो आपको देखना पड़ेगा कि which website you are referring, and accordingly you have to find the citation. What is important? See, important things while keeping in mind the memorial, Nandita, I believe that is something that I've already talked about in this session. So there is a lot of essentials that you need to keep in mind. I've explained all of those things. I'll be sharing this PPT with this legal Vidhiya team, and you can go through it. It's a very short and crisp manner it is given. And if you keep all those very minute points in mind, I believe, you can crack the memorial drafting. And again, one more thing, I'll let you know, you people, if you really perform well in moot courts, if you win some of the moot court competitions, or if you win these individual prizes like best speaker, best memorial, best researcher, a lot of this tier 1 law firm takes internships and provide PPOs to those students who are actually very good at moot. The only reason behind, I've seen a lot of my friends only getting tier 1 law firms, and they're not from NLUs, believe me. They're not from top tier colleges. They're not from the national law universities, but they have a very good record in the mooting law schools, and they're hired. They're given a PPO replacement offers. They're given assessment internship opportunities at several tier 1 law firms. That is only because if you're good at the moot court competition, you have 4 to 5 skills already developed that is needed in a law firm culture. You have good drafting skills. You are good at drafting memorials. You are good at doing research at a very short and crisp timing. We're good at briefing cases because cases are of thousands or hundreds of pages. You are good at that, briefing it done. You are good the way you are presenting yourself, your oral argument, your communication skills, and everything. These are the very 4 to 5 basic matters that matters while you are giving interviews, in a law firm for internships or for a job opportunity. So in case if you are really good in moots, and if you're not from top NLU or top law colleges, doesn't matter. You can still get into a top tier law firm if you're performing well in this moot court competition or trial advocacy or all this kind of competition. And that is the only reason you see a lot of these tier 1 law firms and tier 2 law firms are now associating with different colleges and with different, as I'm talking about the amicus theory only. we have collaborated with different law firms, different tier one law firms for our Moot competition that we go for. So previously they don't used to do that. Right now, they have this facility and they collaborate with us. And I have seen a lot of people, a lot. You see the 2023 competition that the Amicus Curie organized. The colleges that have won the competition are not any tier or like any top NLUs. Though we had teams from NLU, Delhi, Bombay, Nalsar, but the team that won was a Kerala Law Academy in Kerala, and I believe there is another team, Reva University in Bangalore, that won the runners-up prize. So these are not very, in top NLUs, but still they've got this internship opportunities at these top tier firms that have collaborated with us in the Moot competition only because of the skills that they presented. If you really want to go through that, then you have to have some good amount of good experience in the mooting field and related competitions. PPT, I believe, I've again told PPT, I believe the organizing committee would be sending. Current 5 years course, which semester will be started? Rupesh, first semester, you should start doing the internship. It goes from base to base. I believe for first, second, third year students, Legal Vidhiya provides an internship opportunity. So there are several other opportunities that the Amicus Curie also provides. So you can apply for internship in the first, second year in the Amicus Curie or in the Legal Vidhiya team as well. So that will help you to give the basic understanding of the thing. So then you can go for an NGO internship and court internship, and then again and again. So first year, if your question is yes, no, I believe all the semesters should be utilized equally, and you should go for internship after every semester. Yes, Vaishnavi, it should be the same. Yes, Rupesh, this kind of internship, I believe Legal Vidya that provides, that they teach you. They have the internship coordinators, I believe, and they will teach you because it is well known to us, being there in this legal industry, that as a first year student, you won't be knowing a lot of things in the law. So it's not a problem. You are not walking alone in this path. There are a lot of students first year. So again, we'll be teaching you people. I believe they'll be guiding you people. There are coordinators that guides you throughout the process, and they will be helping you out. So I believe that is something you can do. So I believe that is all. I've tried my best. I really don't know on how far I'm able to convince you people with my answers, but I've tried my best to deliver everything. So I really hope that you people have enjoyed everything. And if you really did, then I would really like all of you people to at least, write the feedback over LinkedIn. You can tag Legal Vidya and you can tag me. And you can share your feedback in the LinkedIn. And I'd really love to see whatever you've learned throughout the session. And you can connect to me on LinkedIn. And if you really wish to intern at the Amicus Curie as well, you can get in touch with Legal Vidya. And I believe we can get in, or you can follow the LinkedIn page of the Amicus Curie, and you can get an internship at Amicus Curie as well. So that is something. Thank you. Thank you so much. Over to you, Ria.
Thank you so much. Now I would like to invite Ms. Sakshi Sharma, founder of Vidhiya, and has been awarded as Young Entrepreneur by R&D Global University. Welcome you, ma'am.
Thank you so much, Ria. So, firstly, thank you so much, Rupam, for joining this session and taking out your time to come here. It was indeed a wonderful session. We had more than 400 participants, some on Google Meet and some via YouTube Live. They were all really enjoying the session, and so did I. I as well enjoyed your session a lot. So, thank you so much once again, Rupam. We really look forward to having you once again with us. It was a great session, and before you go, and a big thank you for clarifying the queries of all our participants. They were really enthusiastic, I'd say, and so were you while answering their queries. So thank you so much once again.
Thank you, Sakshi. Thank you so much. Thank you for inviting me. Thank you once again.
Thank you so much. And I'd request all the participants to please fill the feedback form that we have provided in the link. It will be really helpful for us. So thank you so much, Rupam, and thank you to all the participants who have joined this wonderful session. Thank you so much.